The older you get, you start thinking back, well, should I have done this different or should I have done something else? And it's human nature to always think about maybe I should have turned right instead of left, or maybe I should have done this, or maybe I shouldn't have done that. But I actually, at the end of the day, don't have any regrets at all on the choice. I can actually be proud of how satisfying my career was, but also what I contributed. And hopefully, and I've seen some of this, hopefully some of the mentorship or modeling for law students has paid off because some of them now are very good consumer law lawyers and very good lawyers in other areas also.
So can you tell me how you first started off in your career and I guess how you got into consumer law?
Well, I graduated from University of Oregon School of Law in 1972. And while I was in law school, I interned at Legal Aid Services in Eugene. Although my internship was basically on family law, accompanying people to default hearings. That was something I was never really interested in, but I was interested in the work that Legal Aid did. It just seemed like they seemed so fulfilled and so interested. And when I graduated in 1972, I had a choice. I could join my uncle's law firm in Eastern Oregon and basically do estate work, or Legal Aid in Portland had an opening for a staff attorney. And I chose to go to Portland. We started out with a true legal aid concept of neighborhood offices where people would walk in off the street or they had appointments. I can almost visualize the day the client came in with a car dispute with no easily solvable issue, but it turned the contract over. Back in those days, the contracts are about this long and they're single spaced, 50 single spaces on there. And one of them was an acceleration clause. An acceleration clause is basically a clause that says if you default on the contract, miss a payment, then the entire unpaid balance is immediately due and payable. And for a number of reasons under truth in lending, that acceleration clause and the result of acceleration had to be disclosed on the front of the contract and not the back of the contract. And the damages are only $1,000, but I can't really solve the car issue, so maybe we can do something with this. And you got your choice. You could file a lawsuit in state court or you could file a lawsuit in federal court. I was young, didn't know what I was doing, so I said, why not federal court? Never done that before. And after 2 or 3 years of litigation in federal court and the Court of Appeals, we ended up in the U.S. Supreme Court. It's getting better now, but back then, a lot of attorneys weren't familiar with consumer law. And attorneys, like everybody else, have to be able to earn a living, and earn a living means they have to get paid. And to get paid, typically your client is going to be lower income and they're not going to have the ability to pay the attorney. So that means you need to collect the fees from the other side. And to collect the fees from the other side, you've got to make sure as much as you can that you've got a successful case. Because otherwise you could put in 100 hours of time and not recover anything. Your client's never going to be able to pay you. Back then, there was clearly a caveat emptor, which means let the buyer beware. It's kind of a trite term that we've all heard, but let the buyer beware. You go out in the marketplace, you're on your own out there. It's whatever you can do. And if you're an unsophisticated consumer, even if you're a business owner, it doesn't mean you're a sophisticated consumer. You're kind of at the mercy of corporations, of big business, so forth. And then in July 1st, 1969, Congress enacted the Consumer Credit Protection Act, 15 U.S.C. Section 1601 and following. Title I of that was the Truth in Lending Act, and that was followed by a number of other titles: Fair Credit Reporting Act, Fair Debt Collection Practices Act, Equal Credit Opportunity Act, But what that did was switch the caveat emptor to caveat venditor, which means let the seller beware. Because it was kind of a Wild West show back then, once these laws went into effect, case law, particularly on a federal level, hundreds of cases, thousands of cases, more cases than you can shake the proverbial stick at. During that time, though, I left legal aid and became the director of the Lewis and Clark Legal Clinic for Lewis and Clark Law School. Students would sign up for a class for credit, and they'd come down to our office. We were in downtown Portland, and we'd represent for free low-income individuals. We had a landlord-tenant component, which I didn't have to do, and we had a family law component, which I didn't have to do. And so that left the area of bankruptcy and consumer type stuff. And both of those are like perfect teaching vehicles for law students. You can just see the results of helping an individual in a consumer issue who otherwise isn't going to be able to find an attorney. It just seemed like an area where you could really do some good. It was fun, and it was even more fun when you have working hand in hand as a colleague with a law student.
So if you were to explain consumer law to someone who had no idea what consumer law was, maybe just they didn't really know much about law in general, how would you go about explaining that?
That's a good question. That's one I've been thinking about. So what is consumer law? We live in a marketplace. Everything that we do involves buying and selling, everything from buying a cup of coffee to getting a mortgage on your house. And so what consumer law is a set of statutes, regulations, and case law that applies these concepts. We want a system where people can engage in these consumer transactions, can live their credit life as they would, make mistakes, not always get the best deal, have their failures, but those mistakes and those failures should not be based on overreaching by the other party, any type of fraudulent or misleading representations in any aspect should not be based on sex, race, gender, religion, disability. Everybody's a consumer. The CEO of a major corporation is a consumer. Even if you're a lawyer and your client is a corporation, people on the board of directors, the other attorney, are all consumers. So it's not just the low-income individual out there who's engaged in trying to get a credit card or has a dispute over the quality of an item of their purchase. Consumer law is so pervasive, it affects everyone. The term access to justice gets thrown around a lot, and it's got a lot of different meanings. Not everybody's entitled to an attorney. Not every criminal defendant is entitled to an attorney. You actually have to it's got to be severe enough that there's potential, if I understand it, jail time in order to get an attorney. In the family law area, where attorneys could really be helpful, you're not entitled to a free attorney in that. And in the consumer area, where oftentimes the playing field is not only not level, it's completely tilted in favor of the seller or the creditor, you're not entitled to an attorney.
And where do class actions fall in the mix here?
Class actions are important because you can resolve an issue for a whole lot of people with one piece of litigation rather than doing a lot of piecemeal litigation that simply would not be feasible. Kind of the example, are you familiar with the British Petroleum case? So what happened, as you may remember on that, was British Petroleum was charging a debit card fee at the gas pump without prior disclosure, and that violated the Unlawful Trade Practices Act. It would have been impossible to litigate, and the class ended up to be something north of 2 million people. So can you imagine 2 million individual pieces of litigation? It just wouldn't happen, not to mention that the vast majority of those 2 million wouldn't even know that there was a violation. And you know what cypre?
Yeah, can you explain that just a little bit?
Cypre is a Anglo-French term that means to make the result as close as possible to the original, kind of. And so in a class action circumstance, it got all these damages, multi-millions of dollars of damages. And once all the money was sent to the class members, there were a ton of people who either didn't cash their checks or didn't file a claim or whatever, so those got all this money left over. And typically what would happen then is that excess money in a class action goes back to the bad guy, to the corporation, the defendant, the person who lost. But Oregon had adopted, about the same time as the litigation, the concept of cypre, which means this excess money doesn't go back to the corporation. It's intended to be used as close as possible for the intent of the original litigation, which was consumer justice. Class actions are not easy. They take anywhere from 3 to 5 years or longer. They're very upfront costly, and so you have to have the ability to fund those. You have to have some other source of income if you're the attorney coming in, because you may not win, and even if you do win, it may be 3, 5, 7 years down the line.
I get the sense just from everything I've learned about you and your career that you took this path, to help people. Can you just tell me about why?
Why? Well, it's clearly not about the money. It wasn't about the money, because you're always on a salary, and sometimes not a very large salary. I guess I chose this path, particularly in the consumer law area, because it was very satisfying to help people, even if it's just advice only, or if it was actual representation, if it was helping with legislation, if it was doing writing, if it was doing speaking, if it was doing program planning, it was offering outlines. And I enjoy doing it now, because when I retired, you can't just at 5 o'clock turn the lights off and that's it. You have to stay engaged, and this is important stuff.